it can be a very daunting task and a very scary task, a very scary experience when you see that you are sued by a debt collector or an original creditor. Most people fear original creditors more than they fear junk debt buyers, debt collectors. But you don't need to fear. Both of them have the same kind of problem, as I said in my previous video. They have a paperwork issue for different reasons. But there are several ways how you can defend yourself when you actually have a debt buyer case filed against you. There are several ways you can defend yourself. And I'm going to give you three of them. I mentioned one of them briefly in my previous video. You need to understand the rules that govern the particular civil procedure in your jurisdiction. I say they have to sue you, one, in the place where the debt arises. The contract was basically entered into. They can't sue you outside of that jurisdiction. So you are able to defend yourself using that. If the case is coming from somewhere else that you used to live, you can use that as a defense to get the case thrown out. You are able to prove that the contract or the agreement was established in a different jurisdiction than the one that they are trying to get you in. Another defense that you are able to mount once the case is filed, as I'm talking now in respect to cases that are filed already. The other that you can use, and you gotta make sure that you look at your case, your court, your state's statute of limitation. What the statute of limitation does for you, it gives you a defense, so it becomes an affirmative defense to get that case thrown out once the statute of limitation expires. But every state has different statute of limitation, and different kinds of debt carry different kinds of statute of limitation. So you have to make sure you have the right kind of debt. I am specifically here dealing with credit cards, but this can be used for almost any kind of debt. So once the statute of limitation has passed, they cannot sue you in court for the debt. If they do that, they violate the Fair Debt Collection Practices Act, because it's a deceptive act to do that. If they actually you can get paid. You can get paid for them doing you that. But you would have to make sure you go down the proper channel, and you will be able to get paid, because they violate that. The other thing that you have to know, because the statute of limitation is up, it's only a few states, very few states have it where the all collections activity have to go away. Most states, once the statute of limitation is up, they still can pursue collection, but they can't sue you. Let me repeat that. They can pursue the collections in most states, but they can't actually sue you for the collection of the debt. They can't use the court as a means to collect the debt. So what they usually do a lot of times when they sue you, they don't want to go to court and do any trial. They want to use that to get you out and pray that you don't answer the case. You have to answer the case once they sue you. They have to answer the case. Different jurisdictions give you different mediums through which you can answer. You gotta learn in your jurisdiction what you need to do to provide a appropriate. Some you can write in or send it in and it works. Some you can upload it online. Some you have to go in person, alright, and submit the documentation. Some have all three of these as the option. You just gotta learn what is it in your jurisdiction that is required. Now, what you do after another thing that you have as a defense, so I give you two already. You have the statute of limitation and you have the requirements that in certain jurisdictions, the case has to file a certain way. Both original creditor, junk debt buyer, sometimes their lawyers know this, but they ignore it because they're banking on the ignorance of the consumer. And if you know that in your jurisdiction, the case has to be filed with the original contract attached, and sometimes the truth and lending disclosure attached to prove how they come by the amount for the debt, you can file to strike that case. And they would have to go back to the court and ask for time to amend it. And a lot of times they will just dismiss it because they don't have the paperwork to get it amended. That is a way to defend yourself again after they actually sue you. Another way, and another powerful way, is the arbitration clause. Most credit card agreements or some of these agreements has within it an arbitration clause. And you are able to use the arbitration clause. So what you would have to do if you don't have the original agreement that they send you, and you can't answer the case, and you have to answer, as I said. But you can't answer the case, and then when you answer, you agree that the debt is yours. They're going to use that to actually get a summary judgment against you. You got to deny everything in it except your name, if it is correct and all of that. Let them prove everything. But as I said in my previous video, you got to deny it in such a way where it's not blatant lie. If it goes to trial and certain things come up, the judge can say, okay, you lied to the court. You got to deny it in a certain way, and word it a certain way where it give you a leeway where you can navigate around it. But you got to deny everything. Let them come and prove it. Don't give them any easy way out. So what you do next in it, because in this video I just want to deal with how to answer them and what you can use as a defense. In another video we will deal with other stuff. When you answer, you can use the arbitration clause in the contract or the agreement to get the case stayed or outright thrown out. Alright? In most jurisdictions, you can use it because the federal rules require just one party can actually elect to go to arbitration, and the judge is going to go that way in most cases. But one of the things that you have to make sure you do if you are going to use it, so in case your case go further, because you will have to file a motion to get the case stayed or dismissed to use the arbitration provision. Even though you're going to have it listed in your affirmative defense, and I would tell you, file the motion at the same time when you're filing the answer to the case. I am not a lawyer. Let me give the disclaimer again. I am not a lawyer. I'm telling you just from experience in the field and doing research, right? Experience and research. Not a lawyer. So this is not legal advice. I'm just walking you through what you can do from experience. Get a copy of the agreement if you don't have the original. You can go to the CFPB database, put in the name of the bank and the credit product, and it will give you the agreement, and you can search it to see if there's an arbitration clause. Or you can reach out to the creditor, but I don't know if you want to even have any conversation with them. You can reach out to the creditor and ask them to send you a copy of the agreement that governs the product that they have. And then you once there's an arbitration clause, in your affirmative defense, when you answer, make sure you list that there's an arbitration clause, because if you don't do that, you can run into problems down the road. In another video, I will tell you why you need to do that. So what you actually do is list the arbitration clause, file a motion to compel arbitration. And the judge, in most cases, if you do it the right way and follow the procedure that they're going to grant you, and the case will have to be stayed till after arbitration. A lot of times, the bank or the junket buyer, a lot of times not going to actually pursue you because the arbitration will be really expensive. And they don't want to spend that amount of money. And even in a junket buyer case, once it has an arbitration clause and they buy it, they are not governed by that because they assume all the terms of the contract. So whether this is an original creditor or a junket buyer, input the arbitration clause, and that's the way how you can defend yourself. Those are the ways you can strike the case, if there is certain requirement that they have to file in order to carry you there, you can get it strike where they have to refile it, and a lot of times they're not going to because it will cost them more to do it. You can use the statute of limitation, defend yourself. You can use the arbitration clause, alright? These are the ways how you defend yourself in collection case before it even go to trial, and sometimes they will outrightly dismiss it. But remember, you must answer the case. And in your answer, make sure to state the arbitration. Make sure to state it. And make sure you answer, because if you don't answer, they will get a default judgment against you. And you must turn up at court. If you don't turn up, they will get a default judgment. A lot of times they will not have the paperwork. Don't settle right off the top. Because even the day when you go to trial, the judge might send you to go and do a settlement. And by then, there's other things that you can do to know what they have on you and what they don't have. I don't want this video to be too long. So peace. Thanks for listening. Credit Nerdery. Peace.